All right, ladies and gentlemen, welcome back. We are here today with attorney Barney Connaughton, is a family lawyer and mediator who has been practicing family law in Chula Vista and San Diego, California since 1993. His practice has included representing clients in contested traditional divorce cases, representation in collaborative cases, and serving as a mediator in mediated cases. His practice is now entirely focused on divorce mediation. He serves as a family law settlement judge for the South Bay branch of the San Diego Superior Court. His practices focuses on providing clients with options so they can divorce in a healthy way. His education and training includes graduating from UC Davis 1989 with a bachelor's of arts degree, a double major in English and political science. He graduated from Cal Western School of Law in 1992. Ladies and gentlemen, I'm super excited to have attorney Barney Connaughton here today. Barney, how are you?
I'm doing great, Joe. Thank you so much for bringing me on.
Absolutely. We're super excited to have you today on Commercial Real Estate Investor Club. There are a lot of opportunities here as an attorney, as an investor, as a commercial real estate broker, and that's part of why I wanted you here today. We met the other day and you shared a lot of things that really triggered some ideas for me and some opportunities, like I said, for both of us. And, as economies kind of slip and slide a little bit, as we've been seeing, I know that finances get kind of ugly. And then sometimes the natural progression is potential, clash of the titans between spouses. And unfortunately, some end up in divorce. And then this is where you kind of come in and maybe settle things out amicably. And that's why I wanted to talk to you today about is like, what are the options before making it very, very ugly?
Yeah, so definitely, the most traditional way of getting divorced is for both spouses to go and hire an attorney and kind of meet with that attorney and work through the court process to sort things out. But there is this other alternative, which is divorce mediation, where instead of hiring attorneys, they hire a neutral professional. I am an attorney, but when I mediate, I am not acting as an attorney. I'm acting just as a neutral educator and guide to kind of help the couple get in a place where they can make good decisions by getting educated on the law, understanding what the law has to say so that they know what their rights and responsibilities are. But again, this education comes from a neutral place where I'm not advising them, but I'm just giving them the information they need to make the decisions themselves. And it puts me in a position where I can work with both of them, which is super important and valuable to be able to sit down with both of them and make sure they have the information they need. They have the documents and the listing of their assets and debts that they need. And then we can move from there to get creative and provide a variety of options to consider. We can also let them know what a court would do and kind of what the traditional form of resolution might be. But when we start looking at real estate, especially, it's really nice to be able to get creative sometimes, given interest rates, given what the market looks like and whatnot. So mediation provides the couples with a great opportunity to explore, maybe there's a better way of doing it than maybe what the court would do in dividing up property.
That's awesome. That's awesome. I've been in real estate a long time, pushing almost 30 years here. And normally when my clients come to me, they already have divorce attorneys, already one per side, or maybe one has one and the other doesn't. What is the best way to make it known for realtors out there? What's kind of the best way to let them know about this as an option? Because a lot of them don't know about this as an option.
I think that's the biggest failing of us mediators is letting the world know that there is this other option. I mean, it's just too commonplace that people go, okay, my first option is going and hiring an attorney, when I would say a majority of couples are completely capable of sorting this stuff out with the assistance of a neutral mediator, maybe educating them and showing them the way, instead of them each getting their attorney, because using the courts is a really long process and an expensive process, whereas finding a way to get to the table much sooner, which is really the process of mediation allows for that. It allows really for the couple to immediately get sat down at the table. There's obviously things that stand in the way, like lack of trust or anger and resentment, or all those emotional things that might come with the breakdown of the marriage. But if the couple can kind of get past that stuff and get to a place where they're willing to work with each other and look for a reasonable, fair settlement of the issues that need to be sorted out, then mediation provides really a great tool for them doing so.
Now, divorces usually take long time, sometimes months, sometimes years. What's typically like the average start to finish if they went with you as an option?
Yeah, part of it is depending on how much information they need to gather. Once they've so California has a disclosure requirement. So before couples can get divorced, they're required to list all their assets and their debts and their income and their expenses and exchange, supporting document to verify values of their assets and to verify what their income situation is. Once they've done that and have that information, then they're ready to resolve their case. And so I would say in my mediations, typically we might be in that place in about a month's time. And then it's a matter of being able to sit down and work through the issues and get to resolution. And so within a month or two, my typical mediated case is settled. And then it's a matter of doing paperwork, which might take a month or two to do to work through. And then California has a 6-month cooling off window, so couples won't be divorced until about 6 months from when we jump in. But typically they are resolved and paperwork submitted to the court and process within the 6 months. Whereas with litigated cases, like you say, it's, they can take years. Very commonly, a final trial in a divorce case, in a litigated divorce case, won't take place until probably about 2 years into the case.
Got it. What inspired you to go down this road rather than, just the traditional, hey, I'm going to represent one spouse over the other? What kind of inspired you to go down doing what you're doing?
Okay, well, I began doing traditional divorces. I mean, I've been at this for about 30 years, and until probably about 5 years ago, I was doing both. And for the first half of my career, I was just litigating. I hadn't found mediation. I took a training in 2003 that opened my eyes to the possibility of, wow, I can actually get in the room with both spouses and be part of educating the two of them and working with both of them to explore options. As soon as I discovered that, I go, this is the way that divorce should happen for most couples. Not all couples are capable of it, but for most couples, really, if they're looking for fairness and reasonableness, mediation provides a great tool. And so I found that, and ever since finding it, I was working toward finding out how I could exclusively do mediation, just because it's night and day compared to litigating a case. And so if you've got a couple that is willing to give it a go and willing to be reasonable with one another, it's just provides such an efficient way to get to resolution of a case. And so once I found that, it was like, I'm doing this other thing, which is litigation, which is helping, I guess, pay my bills. And there's, some cases really need that because maybe the other side's not being reasonable. And so we need to go to a judge and have a judge tell that other side how it is. But much more so, the litigation process is pretty cumbersome and it's really hard to get to resolution quickly. So having this other tool, mediation, was, for me, it just made the most sense. And finally, about 5 years ago, was when I was able to fill my entire practice so I could no longer take litigation cases. And so all the couples that I work with now, we get to do this better way of doing things, which is mediation.
Awesome, awesome. Now let's talk a little bit deeper about the real estate. If there's real estate involved, maybe take us through the process of like A through B or Z, maybe. I don't know how far you could take it, but if somebody had like a large amount of assets, a big portfolio, what would be the steps to do?
Yeah, so I'll start with kind of the litigation model. Really, what you're looking at is deciding: are you going to have to sell the asset to divide it, or is one spouse going to buy the other spouse out of the real estate? And if you are if there's conflict, and they're fighting over who, they both want to keep it, then it can turn into a mess, and it can become, it's got to be sold and disposed of that way. If there is the other big part of it is over the last couple of years, interest rates have gone up pretty dramatically. So a lot of the couples that I'm working with, they're when they did their financing and the purchase of their property, interest rates were low, and they're like below 3%, and so as they're getting divorced, if somebody wants to buy the other one out, now we're looking at interest rates of over 6. In a typical case, the court would require that the other person be removed from the loan if one person is going to buy the other spouse out. In mediation, we can have the conversation about, what about keeping that existing loan there and just putting protections in place that protect maybe the spouse is getting bought out, and maybe spreads the benefit of that low interest rate, the value being kept with that low interest rate mortgage, spreading that out between both spouses, so they're both benefiting from a decision to be able to keep that lower interest rate loan in there. Ultimately, the family, is receiving a benefit from that by not requiring a refinance. So, in a mediation setting, we can have those conversations. We can explore, how do we take advantage of this low interest rate and not lose it and have it refinanced in a way that feels fair to both sides, and again protects both sides. And so. In a litigation setting, you're really not seeing even that conversation. It's either you got to proceed with the buyout and refinance and buy the other person out, or you've got to sell the property. So definitely in that scenario, being creative makes a lot of sense, as long as, again, we're very thoughtful about protecting both sides.
Perfect. Now, as far as the financing goes, you mentioned a very interesting point where I'm starting to see people get into trouble with their asset because the interest rates jump from 3% to like over 6%. And sometimes there goes some of the equity as well, because for whatever reason, it's not cash flowing anymore or non-performing or what have you. Have you seen that the lenders being very cooperative with the refinance, or what have you been seeing lately in this market?
So I guess I haven't seen so much. I mean, one big question is the loan assumable, right? If there's if they're both on the loan and one of them wants to get the other person off, the option typically is assuming the loan. So the bank letting the other person off the loan, or refinancing, assuming there's not an agreement to do something else. So I had heard about assumptions of loans years ago, but I had never really seen them. And I have seen more recently people successfully moving forward with assumptions. So that's really the only way that I see the banks allow somebody to get off. If the language in the contract for the original loan allows for an assumption, then I think they can proceed. The court the banks have no incentive to do that, because shoot, why are we going to allow a sub 3% loan stay in place when we can make them now pay a 6% or more on the loan? So I haven't really heard of banks being, oh yeah, we'll just let you off. But if there's an assumption option, that's something worth exploring.
Now, Barney, I'm so glad you're touching up on some points that I've been talking about for a while. Now, on the record, we didn't script this out, right, Barney?
No, not at all.
So, ladies and gentlemen, this is very interesting that he's saying some buzzwords that you need to pay attention to, where creative deals, this is the way to do it. Barney also mentioned about assumption loans. So, ladies and gentlemen, I've been talking about that for a long, long time. Last several months, if not last couple of years, this is how we're going to get deals done. And when there is a potential divorce situation, either A, reach out to Barney where they could settle it out amicably and peacefully, or B, you know what, let's start disposing the asset. And either way, this is, I think, where Barney and myself could be very valuable to you if you're the borrower or owner of a property or asset. And so the idea here is really to bring some education. We have a very seasoned pro, as I read Barney's resume, and myself being a real estate broker for almost 30 years, there's going to be a lot of things going to happen as the market starts to shift. Now, Barney, what other things have you been seeing in the market, maybe real estate related, business related, anything that you could bring value to the audience?
Yeah, let me think about that. So I had talked about this thing of one person being willing to stay on the loan, and then ways of protecting that person. So one question I have, I guess for you, and which is my understanding is when you remain on a loan and in the judgment of divorce, the judgment states clearly that whoever is receiving the property is responsible for the payment on that loan. That if the other spouse, even though they're still on this other loan, seeks to qualify for the purchase of their own property, my understanding is with the lending that as long as they can show that judgment that that they're not responsible for that loan, that even though their name's still on it, that when they qualify or seek to qualify for their own loan, that that other mortgage is not considered in income to debt ratio for the qualification for the loan. So even though you're on the loan, because we've dealt with it in the judgment and made it very clear that you're not formally responsible for the loan, that you can do that, which is allowing somebody to go, okay, I'll stay on this 2.5% loan or whatever, and now I'm going to take out this other loan, and now maybe that one's going to be 6%, but I'm going to be able to qualify for that loan even though I'm still on this other loan. So that's my understanding of the current state of things, is that that's the case. And I don't know if you've had any experience with that part of it, but I think it's and then the other part of it is if that person who stays on the loan runs into something down the road where maybe it is getting in the way of being able to secure financing, that will always put like a opt out. Okay, this is no longer working for me, so now I'm giving you notice. Now you got to get me off that mortgage that I've been willing to stay on, so that I can move on with my life. So that we put in provisions that allow for the exit of this kind of arrangement that's giving a kind of a mutual benefit in the event that it's no longer working down the road. So we really kind of think that whole thing through, again, to protect that person who's being willing to keep that first existing loan in place, to protect them if in the future it's no longer working for them.
Yeah, no, you definitely hit up some important points there. And audience, I would just say make sure you hang on to a lot of your records, because that will come into play. If you don't have any documentation that will support what you're saying during that due diligence period, when a lender is doing the underwriting, and you're saying, okay, this is what I understand, but you have no supporting documentation, otherwise you may not get that loan. So Barney is right on point. I am involved in lending myself, so I do have some decent experience around that, where, ladies and gentlemen, definitely make sure you save all your documentation. And this is an interesting thing, Barney. I had a transaction not too long ago where the divorce wasn't fully settled. And then one of the other spouses was not very happy about the situation. Have you had situations like that where things weren't going very well between the spouses, and then it kind of messes up your mediation or divorce?
I mean, I've had the wheels come off before, but I would say most of my mediations we make it to the finish line, and we get, once we get to agreement and they sign off on it, and we get there. Definitely in litigated cases, I've seen, the issue of trying to get a house sold. There's just at odds with each other. They're not willing to accept reasonable offers. There's feet dragging and all these other things. So if there's a way for you to avoid the rigmarole of taking it to court, then mediation really does provide the option of kind of keeping the emotions of it all in check and working through the issues for the benefit of both spouses.
Nice, nice. And if somebody's on the fence, they're thinking about going down that road of getting divorced, um, what would you want to say to them? Like, they tried to communicate. They maybe even, maybe for religious purposes, they spoke to a priest, and they're still banging heads. Like, what would be some of your final words to this potential couple that's thinking about going down the road of divorce or mediation?
Yeah, so I'm all for, if there's a way to fix your relationship, fix your relationship. I mean, if you can go get counseling, or there's some other ways to help work through whatever issues that you're struggling with, I'm all for that first. If you've decided, or at least one of the couple has decided that they're moving forward, then I am a huge advocate for checking out mediation and exploring if that's a possibility. If it doesn't work, the amount that you've put into giving it a go is going to be fairly minimal compared to the huge benefit that you'll receive from it, assuming it does work. And if it doesn't work, then the court's always over there waiting for you to help you sort out your, whatever issues you can't come to terms with, and sitting down with each other to resolve. So it really doesn't hurt anyone to give mediation a go and explore if that's a possibility that'll work for you, because the other process is always there waiting. So make sure you can't fix your relationship, and if you can't, give mediation a go before heading and hiring your own attorneys and doing battle in the courts.
Yeah, you mentioned something prior to our conversation today of your fee as well, and I was kind of blown away what you said. And like I said, I've been experienced as a realtor representing a few people in their divorces, and it's very, very expensive. I don't know if you'd be open to sharing what, like, your typical fee structure, flat fee, whatever. Somebody going into this blind, what should they expect?
Yeah. So my fee structure is I charge $350 an hour of my face-to-face time with a couple, and then once we've gotten to settlement, I charge $2,100 to draft up all the paperwork. And so I would say a typical couple might spend about $3,500 on me to help get them to resolution. There's filing fees that need to be paid with the court on top of that. But again, if you go and talk to an attorney, that's probably below what the retainer is going to be. That won't even really get you through that first hearing that you're going to have in your litigated case. And then you've still got another year and a half of additional work that's got to be done on the case to get it to resolution. So there's a huge financial saving. There's a huge emotional saving, and not beating each other up, and taking all your skeletons out of the closet and putting them into the public records with the court. It's just extremely efficient. It's an extremely efficient way of getting things done. So it's a good place to begin because of all of those things. and you maintain control. It's you and your spouse that are going to be making these decisions, instead of the judge at the court who's going to try to figure things out and make these important decisions about your kids, about your finances. So definitely, it's just makes perfect sense to me, anyways. That why would you not begin with that as a possibility?
Barney, I'm so glad you're open and transparent and such a gamer. I mean, I asked you if you wanted to go live or pre-record, and you were like, whichever. So it tells a lot about your character, Barney, and I really, really appreciate that, because this is what we're about here at Commercial Real Estate Investor Club. We do want to bring incredible value. We want to be helpful in any way we can. And about your fee structure, like I said, that was huge. That really blew my mind away. So folks, pay attention to that, because you may not know of this option. And I really didn't know. I wasn't very aware of this. And I really wanted to bring in Barney to our club to share about this information, because it doesn't have to get ugly. It really doesn't have to get ugly, and it doesn't have to be very expensive either, because you heard it, $3,500 out the door just about on the average is what it takes from start to finish. And if you guys settle it out, well, it's a win-win-win, I think, all the way around. Because what I've heard, and you might agree with this, Barney, that usually the one who wins in a divorce situation are the attorneys.
pretty much, yes.
Well, Barney, you've been great. You've been such a gamer. I love your professionalism. I love the fact that we're also outside of this group in our business networking group. Is there anything else that you would like to add for our audience while I still have you?
No, I think we've pretty much covered it. Joe, I really appreciate you bringing me on and giving me the opportunity to share about what I do. And I look forward to working with you in the future.
Likewise, Barney. Thank you so much. Ladies and gentlemen, please feel free to reach out to Barney. He's located here in San Diego County. His name's there. And did you want to provide your website or any other things you wanted to provide?
Sure. Yeah, my website is www.ahealthydivorce.com. And if you go on there, it'll give you an opportunity to schedule a free consultation to find out more about what I do. And thanks again, Joe.
Absolutely. And you also have a book, Barney, right?
I do. Yes, I did. About a few months ago, I put a divorce workbook out there. It's called Untangling Together. And it really is the nuts and bolts about the emotions involved with getting divorced, the options available. It's written for anybody going through divorce. So even if you've hired your own attorney, it's from my perspective, the best way to handle a divorce is to get the couple educated. And so this book gets into the nitty gritty on the law and the issues that have to be sorted out. So it really strives to educate the reader as to everything they might be encountering in their divorce. And then it provides worksheets and options to consider and that sort of thing. So it's really just a way to give support to anybody going through a divorce. And it's part of it is tackling this responsibility that I feel I have of educating the world that there is this better way of doing it. And before you go lawyer up, consider a process that's going to allow you to work with your spouse and be reasonable with your spouse and get things sorted out without having to involve the courts in doing it.
I appreciate it. Where's the best way to get a hold of your book?
It's on Amazon. So look up Untangling Together, and you'll find the book on there.
All right, perfect, Barney. Well, thanks so much again for joining us on the show today and on the live stream. And ladies and gentlemen, please go ahead and subscribe on our YouTube channel. Feel free to reach out to either of us if you have any other further questions. We appreciate you.
Thanks, Joe.
Thanks, Barney.